All right. Well, welcome everyone. Thank you so much for being here. My name is Juan. I'm the Associate Minister of Unity on the Bay. And I'm really excited and grateful that you have chosen to spend some of your morning with us and the Advocacy Committee. The Advocacy Committee started almost 2 years ago, um, and is really looking at ways of engaging advocacy within our ministry. And one of the main things that the Advocacy Committee chose to do for this year was to really get the word out about voting, how to vote, or the mechanism for voting, I should say, and really supporting people in getting as much education and information so that they can make the choices that they're called to make. We are very grateful that one of our members, Vicki Lopez, is going to be leading today, and she is somebody. She'll probably tell you a little bit more about herself, but she's somebody that has supported us in the past with getting us information about the amendments that we're going to be voting on. And she does this not only for Unity on the Bay, but she does it for other really wonderful nonprofits. And so we're really blessed to have Vicki and her knowledge and her deep wealth of information be a part of today. Before I turn it over to her, though, we're going to pray in. And I also just want to mention Unity on the Bay hasn't taken a position on any of these amendments. And so what you're really going to be hearing today is just more information about it. And what does the amendment actually say? What does a yes vote mean? What does a no vote mean? And because of Vicki's vast knowledge, she'll also be able to give you a little bit of history and some of the work that's gone on behind the scenes for each of these amendments. So you're in for a treat, and we really trust that it will support you in stepping into that divine wisdom within you to be the advocates for what your own values stand for. With that, I'm just going to invite us to take a deep breath so that we can open up this space in prayer and calling forth that divine wisdom that I just spoke of, that divine wisdom that invited us to be a part of this morning, that divine wisdom that has recognized the importance of expressing our voice and awakening the vote. We give thanks for the ways in which we have been brought to this moment, the many blessings and the many resources that have been provided to Unity on the Bay through the Advocacy Committee. And we give thanks knowing that God's peace, God's love, and God's light is definitely inspiring and guiding us during this election season. And so holding the space for a deeper sense of peace, of love, and of light, we give thanks. So it is. Amen.
Thank you, Juan. It was lovely. Thank you for that praying. Beautiful, beautiful way to start. Great segue to what we're going to do today. We're going to very quickly, as Juan said, I actually have been in politics for over 30 years. I'm a former elected official, and I do government and community relations work now with clients. So I have a very good feel for not only the process of the amendments, but the nuances around those amendments. And so I'm going to share my screen now so we can get started. And hopefully, if you have any questions, don't hesitate to just raise your hand or jump in at any point during the presentation. So most people don't know that amendments get onto the ballot through several ways. And one of them is through citizens' initiatives. And Florida actually allows citizens to initiate those, and they are required to get signatures from actual voters, registered voters, that are equal to 8% of the votes that are cast in the preceding presidential election. So what they do is they will take the signatures, and they will, the 8% of the district-wide vote in the last presidential election, which requires at least half of the state's 27 congressional districts. Right, so they'll do like a number, and you'll see the number at the next slide. So petitions are allowed to circulate indefinitely. Like I could start a petition now, and I could continue to go, but the signatures that I collect are only valid for a 2-year period of time. So any of the signatures that are collected for verification by the state have to be done within a 2-year period of time, which really means that even though it can circulate indefinitely, if you're already collecting signatures, you want to make sure that you fall within that 2-year period of time. And of course, the signatures have to be verified by February 1st of the general election year. So that means that all of the initiatives that you will see on the ballot this year, those signatures will all verified on February 1st. And we'll go through a little bit of that. So the signatures have to be certified by the Florida Secretary of State in order for it to qualify. And the state law gives local elected officials 30 days to verify signatures so that the petitioners can actually submit their signatures on or before January 2nd. So there's a lot of, I tell you all of this because it's important that you know the effort that goes into citizens' initiatives. The signature requirement for this year was you had to have collected 766,200 signatures. It's a lot of people, and they all have to be registered to vote, and they all have to be verified. And to qualify for the ballot language to be reviewed by the Florida Supreme Court, you had to have had 10% of that, which is 776,632 signatures. And the reason I tell you that is because language has to be verified by the Florida Supreme Court to ensure that it is in keeping with the state law about how ballot initiatives are shown on the ballot. So of the 91 measures that appeared on this, there's been 91 measures that have appeared on the statewide ballot since 1996 through 2018. The average number that appeared actually on the ballot were 7 to 8. You might recall that a couple of years ago, 2 years ago, we had 13 of them. And that was quite a bit. We did a little bit of there was a lot of trying to put initiatives together that did not actually were not associated with each other. So there was a real outcry 2 years ago. And so this year you'll see that we only have 6. And between 1996 and 2018, 75% of the statewide measures were actually approved by voters, while almost 25% were not. So it's important to note that typically initiatives will, in fact, have a high passing rate, which is why there was Amendment 3 in 2006 actually raised the requirement for a constitutional amendment to pass to 60%. It used to be 50% plus 1, which was, actually the majority of vote, but now it is 60%. So between 2008 and 2018, 4 measures were approved by a simple majority, but failed to meet the supermajority. And that's an interesting statistic because it would have, had we not changed the requirement in 2006, 4 of those would have passed because they had reached the simple majority, which is 50% plus 1. But they were defeated because they failed to do the supermajority, which is what we call 60%. And in 2018's measure, Florida Amendment 1 received a simple amendment majority of 58%. So it can be very, very close and it will still be defeated, which tells you that 58% of Floridians wanted Amendment 1 to pass, but because it did not reach the supermajority, it failed. So take a look. In 2019, the state legislature was in session. So this is the last year's session from May 5th to May 3rd of 2020. And they were able to place constitutional amendments on the ballot. So we've just reviewed citizens' initiatives. Now you're going to take a look at what happens when the legislature is permitted to pass an amendment that would be an initiative that would be an amendment. They are not required to collect signatures. They're not required to go through the sort of rigorous process that citizens' initiatives are required. So in 2020, the state legislature was in session from January 14th through the 13th. I want to just quickly tell you that we changed the dates on even years and odd years because of the presidential election. So this year, because we're having a presidential election, we don't go into session until March. On the years that we don't have a presidential election, we can start the process a little earlier. So here were the 2 that were referred from the legislature. They referred 2 amendments by unanimous vote in the Senate and House. It does require a supermajority in both chambers to pass the joint resolution to get on. But the good thing about this was that it was unanimous, both Republicans and Democrats both agreed to these two ballot initiatives. And that's not always the case, but that does give you an idea of the importance of both of these initiatives, the two legislative initiatives, to both parties. And so that's something to keep in mind as we move through the process. So now, there were measures, initiatives that will not appear on the ballot, and you're going to see a slew of them. So, the legislature can certainly file a measure, but if the sponsor abandons it, it won't be on. If they withdraw it, it won't be on. If they tried and were unable to collect sufficient signatures to qualify it for a ballot, it won't be on. And by that, it means, within their own chambers. If the sponsors filed signatures, but they were under scrutiny, and they didn't have sufficient valid signatures, it won't be on. So there's a number of ways. Also, the last one here, some other type of legal action. Sometimes people will bring legal action against a legislative initiative and say it did not, it didn't serve or it wasn't explained well enough, and so it won't appear on the ballot. So here's a couple of legislative initiatives that were filed this past year that are not going to be on the ballot. And they run the gamut between school board member term limits to amending the Constitution Revision Commission. Someone wanted to abolish that. There's a kind of few of them over here on firearms, elections and campaigns, energy. So the list goes on, and they will not appear on the ballot because they did not either get the correct signatures, or the U.S. or the Florida Supreme Court was unable to validate the language of the initiative. There were some in healthcare, lots of marijuana ones that won't be on the ballot this year either. There was transportation, law enforcement, direct democracy, which is obviously anything to do with the Constitution. And then there were some property and education and even an abortion one that did not make it onto the ballot. But here is what is on the ballot, and here are the 6 of them. And we're going to go through each one of them. That you'll see the subjects that they cover, from suffrage to minimum wage, elections, direct democracy, and taxes. So that's going to be the 6 of them, and we're going to go through them right now. Here's the citizenship requirement for ballot. This is Amendment 1 on your ballot. So this amendment provides that the U.S. that only a U.S. citizen can actually vote. He or she has to be 18 years of age, a permanent resident of Florida, and registered to vote as provided by law. Now, because this proposed amendment is not expected to result in any changes to the process, it's going to have zero impact on our state and local government's cost or revenues, right? Because sometimes initiatives increase the cost to government. And we've seen that in the last 2 years. We had a dog racing, amendment that was going to create a compliance issue. So that means more money that has to be spent by government. In this case, there will be no further funds needed if this were to pass. So here's the yes and the no vote. A yes vote supports amending that Constitution to state only a citizen can vote in Florida. A no vote opposes amending that Constitution. But let me tell you that there's kind of a twist to Amendment 1. So Amendment 1, who's behind it? Because I always like to ask myself, especially on citizens initiatives, how did it get onto the ballot? Who was driving this amendment? The amendment is driven by a group called Florida Citizen Voters. And it's a committee that was supported by Citizens Voters, Inc. It's a Florida 501c4 organization, and it was founded by a gentleman named John Loudon, who has supported similar legislation in both Alabama and Colorado. And John has said that these amendments are needed, in his opinion, because surprisingly, the U.S. Constitution and every state constitution, with the exception of Arizona and North Dakota, does not specifically require citizenship to vote. So the Florida Citizens Group, and I think it's always important to know how much money has been spent to actually gather the signatures, do the expenditures. This particular group spent $7.86 million to get this initiative on the ballot. But here is how, this is a distinction without a difference. This is what we call when there is language where there might be a distinction, but there's no difference. So currently, the Constitution reads, every citizen of the United States who is at least 18 years of age and is a permanent resident of the state, if registered as provided by law, shall be an elector of the county where registered. This would change it to, instead of reading every citizen, to only a citizen. And most of us feel there is absolutely zero difference in this language. It just is a different way of saying the same thing. Because in fact, the term citizen means you are a citizen of the United States. So when it says every citizen, it means you can't, so if you're not a citizen, you're not allowed to vote in the state of Florida. So this is kind of a little interesting twist. In 2019, neither Florida nor any state locals generation allowed any non-citizens to vote. So that's important because the Constitution currently does not permit it. And of course, Florida law requires that you be registered to vote, and you have to be 18 years of age, and you have to be a citizen, and you have to be a legal resident of Florida and the county in which you're registering. So there's plenty of protections to ensure that if what really Mr. Loudon is trying to do is to ensure that only citizens vote, it already is secured in the Constitution. So are there any questions on Amendment 1 before we move to Amendment 2?
No.
Okay, great. So now we're going to go to Amendment 2. So Amendment 2 is, it raises Florida's minimum wage. So here's how the language reads. It's going to raise the minimum wage to $10 per hour effective September 30th of 2021, so next year. Each September 30th thereafter, the minimum wage is going to increase $1 per hour until it reaches $15 on September 30th of 2026. And from that point forward, then any future minimum wage increases will revert to being adjusted annually for inflation, okay? Starting in 2027. The state and local government costs will increase, obviously, to comply with the new minimum wage levels. Additional annual wage costs will be approximately $16 million in 2022, increasing to about $540 million in 2027 and thereafter. Government actions to mitigate these costs are unlikely to produce any material savings, so other government cost and revenue impacts are both positive and negative, are certainly not quantifiable at this time. So let's take a look at the history. So no, let's first take a look at yes and no, because that's important. So if you mark yes for this, you support the initiative to increase the state's minimum wage incrementally for $1 every year until you reach $15 in September of 2026. If you vote no, you oppose the increase in minimum wage. So all would stay the exact same way it is today. So this is how it looks, $8.56 to $15. So it's very simple incremental increases. And who's behind this? So Florida for a Fair Wage is the leading campaign in support of the initiative. You might remember the name John Morgan. He's the chairperson of the campaign. John has been the person who has led the medical marijuana and the recreational marijuana initiatives in the past in Florida. John says that a higher wage is good for businesses because it increases individuals' spending power, and that higher wage would result in less dependence on public assistance. He has spent $4 million gathering petitions for this particular amendment. Now, here's who opposes it. So there is this school of thought that if you pay people more money, then you will infuse more money into the economy. The people who are opposed to it are the businesses that would have to pay for it. So the Florida Restaurant and Lodging Association, which is probably the largest employer of people on minimum wage, because it is our tourism industry, it has said that an increase would have a disastrous impact on businesses and individuals alike. This is their position. That business owners will have to find solutions to control costs, and the solutions will have a direct impact on the state's 1.4 million hospitality workers. And the most obvious solutions, reducing the number of employees, reducing the number of hours for the remaining employees to work, and seeking labor alternatives like automation. So their position is, if we have to pay this, we're just going to get rid of employees, and we might automate a lot of our procedures that now, we have employees, and then we're probably likely to reduce the hours of those that we do keep. The Florida Chamber of Commerce has taken a very big position on this, as have many chambers of commerces around the state. They have said, if this passes, over the next decade, we could lose up to 500,000 jobs. that pay the current minimum wage. So there's two sides to this very it's a very controversial amendment, and I think part of it, you have to see kind of the history of minimum wage, right? Florida last voted on a minimum wage ballot in 2004. It was approved by a 71% to 28% vote, and that's when the Florida's minimum wage went to 6.15 per hour. From 1996 to 2018, there were 26 minimum wage increase measures in the ballot. Two of the measures, both in 1996, were defeated. The other 24 measures were approved, and on average, the 24 approved measures received actually 60% of the vote. You should know that this amendment is polling very high, and it might have to do with the fact that many workers are out of work, and when they do come back into the workforce, are looking forward to a higher minimum wage. In 2020, 7 states passed bills in the legislature for a $15 minimum wage to become effectively incrementally, much like this amendment would result in. If approved, however, Amendment 2 would be the first. Florida would be the first state to actually increase its state minimum wage through a ballot measure. So what you really want to kind of see some of the issues around this particular ballot initiative is that traditionally the constitution of a state or of the United States is not meant to legislate. What has been happening in the past several election years with ballot initiatives is that because the legislature is failing to actually move some of these bills, if you will, or some of these legislative intended situations, citizens are seeking to make right, if you will, through a constitutional amendment. There is a great deal of discussion now as to whether or not these items, such as a minimum wage increase, actually belong in the Constitution. This should have been a bill, much like you saw the 7 states that passed bills to increase it incrementally. This should have been something that the legislature should have done. We're turning the Constitution into a legislative document, which is very dangerous because the Constitution should really be how the government should be run and should not include items like this. But because our legislature has not addressed these items, citizens' initiatives have become a way of doing the work that we believe the legislature should do. So that's an issue on that one. Here's just a really wonderful table of where we were in 2005 when we were at $6.15. You can see that it hasn't really increased. Like between the years of 2009 and 2011, there was no increase. And then there have been some small incremental increases like 6 cents, 12 cents, 14 cents, of which many people say that, in fact, it's not sufficient. You notice on the other column, you'll see the states, Florida's minimum wage as compared to the federal minimum wage. So we are a little bit above, we're over $1 above the federal minimum wage requirement. So no state can have a minimum wage less than the federal minimum wage. You can certainly have more. So we have crept up since 2011 from the federal minimum wage, but there's a great deal of discussion about that it isn't sufficient. It isn't a working salary. Like it's not sustainable. It's not a living wage, and I believe that that's probably why you're seeing it on the ballot now. Just so you can see how Florida compares to the rest of the states when it comes to minimum wage. The very, very dark greens, as you see here, and sort of on the West Coast and on the East Coast, is between $13 and $14. You'll see sort of the southern states, with the exception of some of the Midwestern states, are very, very low. They're still at $7.25. So the surrounding states around us are at the federal minimum wage, and Florida is in the $8 range as compared to, and it's exactly like some of the other states, maybe 3 or 4 other states are in our same range. But it's good to see where we land when we're looking at the rest of the country. So are there any questions on Amendment 2?
I have a question, Vicki.
Yes.
What if like a federal $15 minimum wage goes through and it's supposed to be in less than, in just a couple of years?
Right.
Would that mean that in Florida it wouldn't take place because we actually have an amendment in the Constitution that sort of staggers it?
Well, that's a really good question, right? But by law, I mean, our Constitution cannot usurp federal law, right? I mean, we can. So always look at the federal law as being your minimum. You can make it stricter. You can always make a law stricter. Like remember what happened during COVID, right? The governor said you can do certain things, and then he allowed for counties in South Florida to be even more strict than what his legislative intent was or his executive order because it was coming out of his office. So you can always make it more strict. That's going to be a really good question, however, because we're actually amending our Constitution. So would we be forced to have to amend it again? Is the next question, which is the danger when you're legislating a constitution. But I don't see, if we go back, I don't see the federal government. Take a look at how long they've been at 725 since 2009 with no changes.
Right.
So, there'd have to be a significant change in sort of federal government policy vis-a-vis the Florida minimum wage for it to actually impact us. But you bring out a very good point. When you start amending the Constitution, you're going to have to reverse the Constitution because that is our that's our roadmap of how we operate the state. So it's dangerous. Look, at all of us understand that we need to have a higher minimum wage. We would have all preferred for the legislature to have passed it, to be in keeping with what we think would be a living wage in the state. But the citizens have, I guess, taken it into their own hands and are hopeful that I think it will pass. I mean, it's polling high. So we'll see what the federal government does, if it ever does anything, because it has not shifted at all, which is
Yeah.
really interesting because we've had even in the very worst of economic times, which was the 2008 economic crisis. They only increased it less than $1 and then just kept it constant. So
Yeah.
it's a good question.
Thank you, Vicky.
Yeah, so let's take a look at ballot 3. Now this is going to be one of the most important initiatives we will ever see because this can change the face of elections. So it's really important that you understand where we are with this. So the ballot language is all voters vote in primary elections for state legislature, governor, and cabinet. So what will this amendment do? This amendment will allow registered voters to vote in primaries for those offices at the state level. Um, all candidates for an office, including party nominated candidates, would appear on the same primary ballot. So, for instance, right now, if you are a registered Republican, you will only see Republicans running in the primary. So, and your ballot would not include anyone in the Democratic Party. Same for those that are registered as Democrats. You only see the Democratic candidates. In this case, if this initiative, if this ballot amendment were to pass, all of them will be on the ballot in the primary. The two highest vote getters would advance to the general election. So it could be two Democrats, it could be two Republicans, it could be one Republican, one Democrat, which is the case now. Remember how the primary system works. Democrats pick their candidate, Republicans pick their candidate, and those two advance to what we know as the general election. But so in this case, the two highest vote getters advance to the general. If only two candidates qualify, no primary will be held. So let's say two Democrats qualify. There are no Republicans in it. It used to be you'd have to go through a primary. In this case, we will forego the primary and you'll head right directly to the general election. So the general election will always have two people, just like it does today, except that it might be two people of the same party, which is not what it is the case here. And the candidate's party affiliation will actually appear. So you still get to see who's a Democrat, you still get to see who's a Republican. But the key here, and this is going to be key. Let me quickly, before I move to that language. So 1/3 of Florida's voters today are independent voters. As you well know, primary elections cost a great sum of money. So the independents have been disenfranchised from an election for which they pay for. That's one. Two, because so many people have left the party system, when one third of your voters are now independents, there is this sort of perception, and much of it has kind of played out in our elections, that the very fringe of each party is now electing a very, in the Republican case, a very, 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 very conservative candidate, and on the Democrat space, a very, 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 very liberal candidate. So the center, what we used to call center right, center left, has actually disappeared. So what ends up coming to the general election is often candidates that do not meet either, they're not moderates. I guess that's how we would say. The moderate has disappeared with respect to this because the independent voters are not participating in the primary elections. This would allow everyone who's registered to vote, whether you're Republican, Democrat, or independent, you get to vote in the primary. And you get to vote for any of the candidates, any and all the candidates, right? So it kind of gives the voter a kind of a very open field to determine which person is the best person for the job, as opposed to which party is, and whether or not there are any moderates left in the group by the time we get to the general election. So here's what's probable about this. It's going to result in additional local government costs to conduct the elections. The Financial Impact Estimating Conference, so the legislature has this group that's always looking at how much these things cost, has said that combined cost across the counties would range to about 5.2 million, from 5.2 to 5.8 million for each of the first 3 election cycles, occurring in the even numbered years after the amendment's effective date, with the cost for each of the intervening years dropping to less than $450,000, which is interesting because the first 3 election cycles is when we're going to get started with this. But then the costs drop in the intervening years to less than $450,000, because these elections are costing us a great sum of money. With respect to state costs for oversight, there will be some additional cost, obviously, are expected to be minimal, however, and there are no revenues linked to voting in Florida. So honestly, there's no impact on state costs or revenues on the state budget itself. And this proposed amendment will result in an increase in local expenditures. This change is expected to be below the threshold that would produce a statewide economic impact. So all in all this tells you is that the impact is going to be minimal when we change, if and when this amendment if it's passed. So a yes vote supports establishing what we now call the top 2 open primary system for primary elections for state legislator, the governor, and all the cabinet offices, which is Attorney General, Chief Financial Officer, and the Commissioner of Agriculture. A no vote would oppose it. So you would be leaving in place what we now know is a closed primary, meaning that only Democrats can vote in their primary, only Republicans can vote in their primary, and the independents will be disenfranchised from voting in a primary. And if approved, this would begin in 2024. So we talked about currently what happens. We talked about that it's only going to impact the state, what we call the statewide elections, which is the governor and the cabinet members, and then of course your state legislators. It's going to replace the closed primaries, as we talked about. It's going to provide for any registered voter, regardless of political affiliation, will be able to vote. There's a lot of people that are independents that actually have to change their political affiliation just so that they can participate in the primaries, and then they change back to independence. So that would eliminate all of that paperwork, clearly. And in the cases, as we talked about, where only 2 candidates qualify, the primary would be canceled and we could move directly to a general election. There's a lot of money involved in these elections as well, and you need to know that. People are raising extraordinary amounts of funds to run in a primary, and then again in a runoff, and then again in a general election. I can tell you, I had both a primary, a runoff, and a general election within 60 days. So you're raising money all the time, and of course, there's all the conversations that people are having around the country about all of this money that needs to be raised. Is it fair, and who's really involved in the process when people have to raise as much money as they have to raise to run? So who's behind it? who's behind this initiative. All Voters Vote Inc. is the leading campaign. They believe, this is their position, that the vast majority of races in Florida are decided in closed primaries, which excludes most voters. The closed primaries are decided by small, extreme wings of each party. And because of this, elected leaders no longer have to answer to the majority of people, but only to a very small group of hyper-partisan voters. By giving all voters a chance to vote, politicians will become answerable to the majority of voters and not just a select few. All voters have paid $6.3 million to gather these petitions. But there's an interesting, very, very interesting local person who a lot of people know, Miguel Mike Fernandez. He is the largest donor, having contributed $5.9 million of his own money. And his thoughts are, Florida is among only a handful of states that do not allow all qualified voters to participate in primaries. How backwards is this? Almost a third of voters are registered as neither Democrats or Republicans. So Mike has put a great sum of money behind this because he truly believes that all voters are not able to vote and the elected officials are not even answerable to all voters. So his opinion is looming large on this. This particular initiative is polling very high, but you need to see. Here was what the Sun Sentinel said, the editorial board, and there have been lots of a lot of editorials around the state. They all are in keeping with this message. Florida is the largest of 12 states, clinging to an archaic system in which only Republican and Democratic voters can nominate candidates for office. This is the smoke-filled room dressed up as a polling place to trick people into thinking it's real democracy. It isn't. Open primaries would curb the influence of the most extreme voices in both parties and the narrow-minded lobbies that bankroll campaigns. So that is the opinion of much of the media, much of our established press. And that would be the exact sentiment that All Voters Vote Inc. And Mike Fernandez have about this issue. But it's important to see who's opposing it. And here we go, both parties. The Florida Democratic Party has felt that the language is misleading, confusing, and violates the state's single subject rule. In Florida, we have initiatives cannot be placed on the ballot if they do not address one single subject. So I would not be able to put a tax issue with a suffrage issue with a transportation issue in one amendment, because it would in fact confuse people. And if you are for one of the items and you're not for the other two, then you would be forced to make a choice, right? So we have this law that says you can only have a single subject rule. By the way, that rule was in fact violated in the last election when we had lots of amendments, the 13 amendments, when they tried to piecemeal lots of different subjects into one. The Republican Party has been extraordinarily, they've listed out their complaints about this. And here's what they have to say. They think that it's masquerading an open primary that will allow registered voters to vote in the current party primary system, and that it would actually abolish party primary elections for certain offices and replace them with what they consider to be a free-for-all jungle primary. They believe it would limit voters' options at the general election to 2 and only 2 candidates. And that you can well imagine, because it could be 2 Democrats and no Republicans would advance to the general election. They think it would eliminate any guarantee that voters would be provided a true choice in the general election because each party represents a different ideology and perspective on significant matters of public policy. And that then, of course, then they agree with the Democrats that it violates the single subject rule. I will tell you this. I have had conversations with elected officials on both sides of the aisle, and they are both parties are very opposed to it because they have to raise more money to reach more people. So I want you to picture that if you are a candidate running in the Democratic primary, you are only talking to Democrats. And if you're a Republican running in the Republican primary, you're only talking to Republicans. And usually you're only talking to what we call the super voter, the voter that always votes, right? The ones you can count on to vote. In this case, they're going to have to raise a whole lot more money because they're going to have to start talking to everybody. And I mean everybody. We're talking about their own party, their opposing party, and then those that are independents. And they just are really opposed to this because they like it just the way it is. So it's interesting that both sides of the aisle are very much opposed to this amendment. It's polling high, though, and you can well imagine why. So there's also people over profits. An unforeseen outcome of this proposal, they think, is the loss. This is a really, before I even start with this opposition, this is a very interesting twist to all of this discussion on this amendment. People over profits really believe that there could be a loss of minority representation in both legislative chambers because they feel that people of color would all but be erased from the process. And this is why they say Republican independent voters in a Black majority district would allow a white Democratic candidate the opportunity to defeat a Black Democrat in the context of a larger general election electorate. So it would eliminate third parties from competing in the general election. And that's true. Third parties like, the Green Party, they might or may not, but I mean, they'd all be on the primary ballot. So I think people over profits is worried because we do have Black districts now. And usually a Black Democrat has a really high chance of winning his or her primary in a Black district. But if a white Democrat gets in it, they think that, if everyone's voting, they will vote against the Black Democrat. So this is something to consider, although I just don't see it happening. I do not believe that it is the party system and the primaries that has contributed to Black, representation or having Black legislators. I believe it's been the way we draw the district lines that has really made a difference. You'll have to decide which one's more important, that we get to vote on everybody and these people have to speak to everyone and be accountable to everyone. I think that I'm not convinced about this particular item, just because I have seen the impact of the way we draw districts, and when we have been able to draw them appropriately, we've had a surge of Black legislators, both men and women, come to the process. It was when they used to gerrymander those districts to make it so that one party over another, and they would exclude certain neighborhoods, or they wouldn't allow those neighborhoods to be in the majority within the district. So I'm a proponent personally of the way we draw districts, and not so worried about this amendment. But in all fairness, they do have some concerns. So I wanted to make sure that you knew that. So is there any
Vicki, you said when they used to gerrymander, so you're saying Florida, there's no or very little gerrymandering now?
Well, no.
Vicki.
It's gotten a little better because the
Loaded question.
yeah, well, yes, it is loaded. It used to be a whole lot worse, but they've been taken to court. And because this is a federal issue, it's reached the federal courts. So they've had to go back and redraw. Oh, no question about it. They've tried. There's no question, Mauricio, that they're trying all the time to draw these lines so that it benefits one party over another. And remember, the party in charge, the party that's the majority party, is drawing the lines, right? So yes, I mean, clearly, and I don't think this is one party or another. I think everyone's always trying to ensure a majority of their legislators in their party get elected. So yeah, you have to keep a close eye on them. And there's always groups that are looking at that, and always groups that are contesting it in court. But in Florida, we've had a lot of have to go back and redraw. So this is an amendment that is it's really a game changer for elections. It could be a game changer for the kind of people that we elect. So there's a lot of this is probably the most controversial of all the amendments.
Vicki, how is the open primary system that we're proposing here different from, say, the open primary system in California and the open primary system that is more typical?
So the open primary system, correct. So the open primary system, as we know it in other states, allows for anyone to vote in any of the primaries. So if I'm an independent voter and I choose to vote in the Republican primary, I could, right? So they haven't made it so that it's the top two go. They continue their primaries. The openness of it means that anyone can vote in those primaries, and Democrats can vote in Republican primaries, and Republicans can vote in Democratic primaries. Ours is really,
And independents can vote anywhere.
And independents can vote anywhere, right? And in this case, we're just saying, we're going to throw them all on a ballot. You're going to get to see what they are: independent, Republican, Democrat, third party, who knows, who cares? And we're just going to advance the top two getters, right? Sort of more of a majority rules over all the candidates, which takes really, Eddie, the party system out of it, right? And it places the candidate, and you have to now recognize who is this candidate, what is their platform, and who cares what party they're for.
But I think that's the nuance that worries people like people over profits, because that little distinction is what creates the unintended consequence that they're worried about.
Yeah, of course. And listen, I don't at all, discount that this may be an unintended consequence. And I think we should look at this very carefully, because, we certainly want to have more diversity in our system, right? More representative of the people of who we are. But, here again, Eddie, I go back to, if everyone registers to vote and votes, I think the part that has been hard on the sort of minority populations has been that they haven't participated in it, and for a number of reasons. And I won't even get into amendment for that. Most minority communities have been struck with a criminal justice issue, so they have criminal histories and they've wanted to vote and they haven't been able to. Like Florida is one of 3 states that doesn't automatically, give you your civil rights back when you're done. So, there are a lot of reasons why our minority populations have been disenfranchised from elections, period. Forget about the fact that we have a party system and a closed primary system. So I'm hopeful, I really am hopeful, that if this passes, there will be a continuation of efforts to ensure that minority populations are registered to vote and actually exercise their right to vote. Because I think they will select people who are most, and again, look, I don't believe that minorities only vote for minorities. I believe they're looking for people hopefully they're looking for people whose policies will impact them or benefit them. That's why we vote. So we'll see. But this is something to look at. It's polling high. This is polling high, and it looks like it may pass. So,
do you know why they chose to go this route? Why Mike and company chose to go this route instead of the more traditional open primary system?
There were a lot of discussions around it. I know there were some people in my Leadership Florida class who have been helping. I think that they just wanted kind of like to make everyone really accountable to everyone. I think it's certain. There's been this. I think it was born of frustration with the extremes, the extreme right, the extreme left, and really wanting people to just say, look, you better look at these people and decide for yourself, of all of the options, who would you pick? I think it was born out of a lot of frustration, Eddie, but I haven't had a conversation with Mike about it. I just think he wants this to be fair. I think if I were a betting woman, I would bet that he has really been frustrated by the fringe groups.
What would it take to get this also at the federal elections in Florida?
Well, we don't really. That's driven by the U.S. Constitution. So, we're just trying to figure out what we are going to do here in our state. So, as you know, all the states get to determine how they're going to do their elections, but they must follow the election law, the federal election law. I don't know what it would take. Remember, a constitutional amendment in the U.S. Constitution requires, a majority of the states to vote on that. And I don't know how many states would agree to this. This will be something to watch. However, I think if it passes in Florida, I wonder if other states will start to move in this direction. Yeah, it'll be interesting. But we don't have the authority to move it into federal elections. At least I don't believe we do. But I'd have to check on that. So, any other questions on Amendment 3? The other amendments are easy. The first 3 are a little bit, controversial. So here's Amendment 4. This one, oh boy. It requires all proposed amendments or revisions to the state constitution to be approved by voters in 2 elections instead of 1. in order to take effect. The proposal applies the current thresholds of passage to each of the 2 elections. I'm going to show you what this looks like. So a yes vote would mean that any voter-approved constitutional amendment has to be approved by voters at a second general election to become effective. And I'm going to show you this in here. This is a great little chart. Currently, a citizen initiative qualifies for the ballot or an amendment, and it's referred to the ballot via the legislature or commissions. Perfect. If the amendment is rejected by the voters, it's rejected. If it is approved by the supermajority, it's added to the Constitution. Simple, right? Here's what this amendment would do. We do the same thing we do now, except that if it passes, it's placed on the next election ballot, and it has to go through the system twice. And you ask yourself why. Well, who's behind? First, let me tell you how many constitutional amendments we've had. Again, I wanted to show you a state, how we compare to the rest of the states. So we're sort of in the middle. We've had a number of constitutional amendments approved since 2006, more so than any other states other than Texas and Louisiana, interestingly enough. Remember, the Texas legislature only meets every 2 years. Ours meets every year. So it might have something to do with it. Don't know about Louisiana. Okay, so who's behind it? Keep Our Constitution Clean Political Committee. Jason Zimmerman is a lawyer, and he believes that voting for an amendment twice would reduce the amount of whimsical constitutional amendments. Florida's had more than 140 constitutional amendments since the 1960s. The US Constitution has only been amended 27 times since it's been around since the 1700s. Jason has paid $6.3 million to gather petitions for this. Why? So this is sort of a way of ensuring that constitutional amendments don't get passed. Most of them, so think back, I know the whimsical ones would be something like dog racing or the vaping, which was passed in the last election. That seems whimsical. That really was an attempt by citizens to do what the legislature wouldn't do. However, it is a burden because you look at the amounts of money that are raised to get these amendments on, and if you've already had one election and it has, met the supermajority, one has to ask oneself if it makes any sense putting it back on a second time and having to raise the supermajority issue again. So that's number 4. Are there any questions on 4? Pretty simple. It's very simple, straightforward. You either believe that once it's passed, it should be added to the Constitution, or you believe it should go through a second filter, the same as the first filter.
Yeah, even right now, and 2 years ago, when the former felons amendment was passed, and still not active. So you're like, whatever.
Well, here's what happened with that, Mauricio, just very quickly. I don't think anyone thought it would pass. And when it did pass overwhelmingly with a supermajority, the legislature decided, and there's been enough written about this that I can tell you that they felt the Republicans knew that the almost 800,000 people that would be impacted by this would probably register as a Democrat and vote Democrat in the next election. And so they went to town to define what it meant, terminate your sentence, right? That's when they legislatively stepped in. I'm not certain that the voters agreed with the legislature's definition of that phrase. We will never know. But I think we learned a very valuable lesson that when you do a ballot initiative like that, the language has to be very, very, very clear. Because, I'd like to think that the majority of us thought people that have finished their sentences have in fact earned the right to be reconciled into society again. But we'll never know that, right? So the legislature then took it into their own hands, because I would say that they probably didn't want it to pass. And when it did, they freaked out. And then they decided, well, now we're gonna make it we're going to make sure, because they knew that all of these people had not paid their fines. But there's many reasons why you can't, because you can't get a job after when you have a criminal record. So it works counterintuitive to the very thing that we want them to do. But you're right. This would have been an interesting second time around.
Yeah, but that's like the problem, because even if you had that language in there, they would just find something else to.
Probably, but it would have been harder. Would have been a much harder fix. So ballot language for Amendment 5 is very simple. So 5 and 6 are going to be very simple. Currently, if all of you own your home, you know about the Save Our Homes benefit. So this would increase the effective date, starting effectively January 1st, 2021, from 2 years to 3 years, the period of time during which you can accrue your Save Your Home benefits to transfer from one homestead to the other. You ask why, right? You ask, why would we need to do that? Okay, well, first of all, a yes vote is you can extend the period from 2 to 3 years. A no vote says, no, I want to keep it at 2. Well, here's why we are contemplating this issue. So currently now, if a person moves to a new home, right, they have 2 years to transfer their Save Their Home benefit to have the new home assessed at less than just value. The amendment would increase the time period from 3 rather than 2. Now, you all remember that in 1992, we did the Save Our Homes that would limit homestead property valuation increases for homes receiving the homestead exemption to a maximum of 3% annually. So your taxes could not rise more than 3%. It was done because we had so many retirees coming here and they were being taxed out of their homes once they were in retirement, right? So the important part about this is that you recognize that there was a reason for that and that it has been working nicely since 1992. However, here's what's been happening. So prior to it, as you know, the market increased, your taxable value increased, therefore your taxes increased. It also prohibited that from going up. It prevented owners from being taxed out, and it also provided a significant tax savings over time, especially when the market was increasing. So when the real estate market was booming, people were paying much more in property taxes. This kept it stable for most people. So here was the significant savings of Save Our Homes, right? So if you have a market value, we can use the first example. If you had a home in year 5 that started at 110, and by year 5 your market value was 192,000, your assessed value went from 110 to 123,000. Your homestead exemption stayed the same each year. Your taxable value began to increase, right? So the taxes with the Save Your Homes was these amounts because it was capped at 3%. Here's what your taxes would have been without it. So here was the total savings. Over a 5-year period of time, people were saving $3,000 on a home that they originally purchased at $110,000. So that was the significant value of having the Save Our Homes. This amendment was actually sponsored by Representative Rick Roth, and it was unanimously passed in both chambers. Here's what the Tampa Bay Times editorial board said about this. This is really important so you understand why the 2 years is not really actually working. People who sell their houses covered by the homestead exemption have 2 years to move into a new house and carry that tax break along with them, except they really don't. To transfer the Save Our Homes exemption, Florida law says a homeowner must have received a homestead exemption as of January 1st of either of the 2 immediately preceding years. So that's what the law says. So someone could easily miss out by selling their home late in the year and then building a new home that isn't finished by New Year's of the year after next. In other words, after only a year and a few days had passed. So this change aligns with what voters had originally intended, that homeowners could take their exemption with them for the 2 full years. So now you see why it's important, right? The example of I sell my home at the end of the year. I've only got one of those January 1st under the belt, right? I buy the next home or I build the next home. I miss the 2. So the 3 gives them the actual increasing from 2 years to 3 years now gives you the absolute comfort level that you will at least get 2 years or more. So it's called, fixing the unintended consequence. as we talk about unintended consequences. This is what we found after we passed the law. Are there any questions on number 5? Okay. Then number 6, last but not least. So this is an ad valorem tax discount for spouses of certain deceased veterans who had a permanent combat-related disability. So this would provide a homestead property tax discount for certain veterans, and their surviving spouses would actually hold legal and beneficial title to and permanently reside on the homestead property until she remarries or sells or otherwise disposes of the property. The discount may be transferred to a new homestead property of the surviving spouse under certain conditions. So what does this really do? A yes would support that the surviving spouse of a deceased veteran would have his property tax discount transferred to her. And a no vote would say that you don't believe in it, that you think it should only be for the veteran, and when he passes away, the wife loses the discount. This amendment would take place on January 1st. Remember that a homestead tax discount is a certain dollar or percentage amount subtracted from an assessed home value, which is used to calculate property taxes. So deceased veterans of a certain class in Florida are given an additional property tax discount because they're veterans and because they've been disabled in service. So this really just says we believe in our hearts that if he or she dies, the spouse would continue to enjoy the benefit of the property tax discount. So in fact, it does actually go into effect unless the spouse remarries, sells, or otherwise disposes of the property. And if she sells the property and does not remarry, then her new residents would receive the homestead discount. So in 2006 is when we passed the law to do the discount. We authorized discounts for veterans who were Florida residents prior to entering military service, disabled in contact, and honorably discharged. In 2010, we extended the homestead discount for active personnel. And then in 2012, we extended it to benefit disabled veterans, and we extended the tax discount to be made available to all combat disabled veterans currently living in Florida, whether they were residents before their service or not, because so many of our retirees did not live in Florida, but have come home to roost here in their retirement, but were disabled veterans. So we have a rich history of taking care of our veterans vis-a-vis this very issue of homestead property tax discount. So it's not a new thing. It's just really another continuation of a lengthy history with this issue. And the support, this was a unanimous support. It was introduced by Representative Sam Kilbrew, and everybody thought it was a great idea. So are there any questions about any of it, about the process? I'll stop sharing the screen now. Is there any questions about the presentation? I am providing the presentation to Unity so they can put it on their website, so you can certainly send the link to any of your friends and families. Clearly not even just in Miami-Dade County, but all over the state, because the constitutional amendments will be on everyone's November ballot if you are a registered voter in the state of Florida. And if there's any questions at all, as you're filling out your ballot, happy to be of any assistance there. So that's my presentation. Any questions?
No, that was very good.
Thank you so much, Mauricio.
Thank you, Vicki. It was great.
Thanks, Sandra. So glad that
Got it right here. I was checking on it as we were doing it.
Oh, good, right? Good. Well, that's the way it's supposed to be done, right? Get that ballot off. And I can't stress enough to everyone, vote, vote, and vote. It's the most important election. And we really do have to get the vote out. It's our right. And particularly now for women, this is the year that we're celebrating 100 years of getting our right to vote. And so I hope that every woman understands the sacrifices that were made by so many women to ensure that we would have that right. So hopefully everyone will get out to vote. Make sure that your ballot gets dropped off somewhere where you know it will be counted. If you're doing a absentee ballot, it's important. You can't always trust the mail. So thankfully there'll be boxes, what we call the drop boxes for your mail-in clients, for your mail-in ballot. So thank you, Hayamara. I appreciate your sweet comments. All right, so if there's no others, then I would say that we've concluded. Eddie, thank you so much for joining. It's great to
No,
see
my pleasure. Thank you for taking the time to walk us through this.
Thank you.
Before we go, I just think it's important to underscore that unlike last time where we did take a position as Unity on the Bay, Unity on the Bay hasn't taken a position on anything in this election cycle. So nothing here should be interpreted as an endorsement on behalf of Unity on the Bay or the Board Advocacy Committee. So we're not making any recommendations. It's all up to you. And hopefully now you have the information to make an informed decision. Thank you, Vicki.
You're so welcome, Eddie. Thank you for that clarification as well. It is important that you use your divine wisdom as you fill out your ballot. So best of luck to everyone, and we'll see you very soon. Thank you.
Thank you. Bye-bye.
Thanks for joining. Thank you, guys.
Thank you.